Your rent just went up $300 and your landlord says it's legal. Your security deposit vanished without explanation. That late fee you paid last month, it might have been illegal. Right now, thousands of Texas tenants are getting blindsided by rental law changes they never saw coming. Sarah Martinez in Houston discovered this the hard way when her landlord suddenly demanded she pay utilities that were included in her lease for 2 years. She fought back, won, and got every penny refunded. Here's what every Texas tenant and landlord needs to know before it costs them serious money. Number 1. Senate Bill 38 rewrote Texas eviction law on January 1, 2026. Senate Bill 38 officially took effect on January 1, 2026, and it fundamentally changed how evictions work in Texas. This isn't a minor adjustment. This is a complete overhaul of the eviction process that affects every single renter and landlord in the state. Governor Greg Abbott signed the law earlier in 2025 as a way to defend property owners' rights. The Texas Apartment Association pushed hard for this legislation, arguing it would help landlords deal with squatters and tenants who don't pay rent. Critics say the new law deteriorates due process for tenants and makes an already fast eviction process even faster. Here's what you need to understand. Evictions in Texas already happen fast. The process is supposed to happen in 21 days. Texas already had one of the quickest eviction processes in the country, but SB 38 tightened those timelines even more and added procedures that many tenants don't understand yet. The law applies to any eviction lawsuit filed on or after January 1, 2026. If your landlord files eviction papers tomorrow, you're operating under these new rules. If you signed a lease last year, you're still under these new rules for any eviction proceedings. The law doesn't care when your lease started, only when the eviction case gets filed. The law shortens timelines for courts to act once a landlord files an eviction case. What does this mean for you? Less time to find a lawyer, less time to gather evidence, less time to figure out your options. The margin for error just disappeared. Number 2, electronic eviction notices are now legal. Check your email every single day. Here's a change that sounds small but could destroy your case before you even know there's a problem. Landlords can now send notices via email or online portals if the tenant agreed to this method in writing, such as in the lease. Pull out your lease agreement right now. Somewhere in that document, probably buried in the middle pages, there's likely a section about notices or communication. If you signed a lease that allows electronic notices, your landlord doesn't have to hand you a paper anymore. They don't have to send certified mail. They can just send an email. Critics say that lots of people's email boxes are full of all sorts of things, so electronic delivery will probably be problematic for tenants. This is a real concern. Think about your inbox right now. How many unread messages do you have? How often do promotional emails bury important messages? How often does stuff end up in your spam folder? Under the old system, landlords had to use certified mail or personal delivery for eviction notices. You couldn't miss a certified letter, someone had to sign for it. But an email, that can get lost in seconds. It can go to spam, it can get overlooked, and if you miss that notice, you miss critical deadlines. If your lease allows electronic notices, you need to check your email every single day. Not once a week, every day. Set up alerts. Add your landlord's email address to your contacts so messages don't go to spam. Check your spam folder anyway. Check any online portal you use to pay rent. This isn't paranoia, this is survival under the new law. The law doesn't care that you didn't see the email. It only cares that the landlord sent it to the method you agreed to in your lease. I didn't see it is not a defense. It went to spam is not a defense. Missing an eviction notice by even a few days can completely destroy your ability to fight the eviction. Number 3, first-time late payments get one protection, but it's very narrow. As of January 1, 2026, if you've never been late on rent before, you get 72 hours to pay after missing the due date. This is a new tenant protection added by SB 38, but you need to understand exactly how narrow this protection is. Here's how it works. If you paid rent on time last month and this month you're late for the first time during your current lease, your landlord has to give you the option to pay the late rent or vacate. That's it. That's the protection. The landlord must give at least 3 days written notice to vacate unless your lease changes it. But here's the catch. After 72 hours or if you've been late before, eviction proceedings can start. If you were late 2 months ago, this protection doesn't apply. If you were late 6 months ago, this protection doesn't apply. One previous late payment during your current lease eliminates this protection. The law doesn't specify exactly how far back landlords can look, but the safest assumption is that any late payment during your current lease term counts against you. If you're month-to-month, your payment history during that month-to-month period matters. If you signed a one-year lease and you're 3 months in, your payment history from those 3 months matters. This is why your payment history is now critical. One late payment, even if you eventually paid it, can eliminate this 72-hour protection for the rest of your lease. And once you lose that protection, your landlord can send a notice that just says vacate, no option to pay and stay. Also, this protection only applies to non-payment of rent cases. If you violated your lease in some other way, you got a pet when pets aren't allowed, you're making too much noise, you damaged the property, this protection doesn't apply at all. The landlord can tell you to vacate without giving you any option to fix the problem. Number 4, the eviction timeline is now 10 to 21 days from filing to trial. The hearing will be set for no sooner than 10 days after the suit was filed and no later than 21 days. Let me walk you through this timeline so you understand exactly how little time you have. Say your landlord files an eviction lawsuit on February 10th. Your trial could be as early as February 20th or as late as March 3rd. In most Texas courts, judges are scheduling trials right in the middle of that window, around day 14 or 15. That gives you 2 weeks from the day the lawsuit is filed to find a lawyer, gather evidence, prepare your defense, and show up to court. But it gets tighter. After the eviction lawsuit is filed, the constable or sheriff has 5 business days to serve the citation. Service means delivering the legal paperwork to you personally. If they can't find you at home during those 5 business days, they can use other methods to complete service. Once you're served, the clock starts ticking on your response time. If the tenant does not file an answer, they must show up to the hearing or risk a default judgment in favor of the landlord. A default judgment means you automatically lose because you didn't respond or show up. The landlord wins without having to prove anything. Here's another critical change: continuances are now restricted. A continuance is when the court delays your trial to a later date. Maybe you need more time to find a lawyer, maybe you have a work conflict, maybe you need to gather evidence. Under the old rules, judges had more discretion to grant reasonable continuances. Not anymore. The new law requires both sides to agree in writing for any continuance longer than 7 days. Your landlord has to agree, and landlords have zero incentive to agree because delay works against them. So you can expect landlords to say no every single time you ask for more time. After the trial, if you lose, the landlord can request a writ of possession. That's the final court order that allows law enforcement to physically remove you from the property. Once that writ is served, you typically have 24 hours to leave before the sheriff returns to forcibly remove you and all your belongings. Number 5, summary disposition allows evictions without a full trial in some cases. This is one of the most controversial parts of SB 38. The new law now allows for a summary judgment process where landlords can ask the court to rule without a trial if there are no legitimate factual disputes. This method was introduced in 2026 as a way to evict squatters on a faster timeline than normal evictions. The process was designed for situations where someone is on the property without any legal right to be there, no lease, no agreement, nothing. Classic squatter cases. Here's how it works. If the landlord files for summary disposition, the tenant has 4 days to file a response. The response must dispute the landlord's claims with evidence. 4 days, not 4 business days, 4 actual days including weekends. And your response can't just say, "I disagree" or "that's not true." The response must dispute the landlord's claims with evidence. You need documents, proof, witnesses, real evidence that creates a factual dispute. If you file a response with actual evidence, the court has to set a regular trial. But if you miss that 4-day window, or if your response doesn't include evidence, the court may enter judgment without a trial. You lose by default. The concern among tenant advocates is that some landlords might try to use summary disposition in regular eviction cases by framing tenants as unauthorized occupants instead of tenants with rights. For example, if your lease expired and you're now month to month without a new written lease, could your landlord argue you're an unauthorized occupant? Legally, no. Texas law recognizes month-to-month tenancies. Boo. The concern is that some landlords will try this tactic anyway and tenants won't know how to respond properly within 4 days. If you receive any paperwork mentioning summary disposition or unauthorized occupant, get a lawyer immediately. Don't try to handle this yourself. Number 6, tenants must swear under penalty of perjury that appeals are in good faith. If you lose your eviction case and want to appeal, the rules just got much stricter. After January 1, 2026, tenants now have to swear under threat of perjury that they're making their appeal in good faith and not as a delay tactic. This is a major change. Under the old system, tenants could appeal an eviction judgment to county court and stay in the property while the appeal was pending, as long as they paid rent into the court registry. The appeal process gave tenants more time to find alternative housing or work out a deal with the landlord. Now, when you file an appeal, you have to sign a sworn statement saying your appeal is in good faith. You're swearing under penalty of perjury, which means if you lie, you could face criminal charges. The law is designed to prevent tenants from filing frivolous appeals just to delay the eviction. But here's the problem: what counts as good faith? If you think the judge made a mistake but you're not sure, is that good faith? If you want to appeal to buy time to find a new place, is that bad faith? The law doesn't give clear guidance, which puts tenants in a difficult position. To remain in the property while an appeal is pending in county court, the tenant must pay 1 month's rent into the court registry within 5 days of filing the appeal. They must continue to pay rent into the registry as it becomes due. If you can't afford to pay rent into the court registry, you can't stay in the property during your appeal. The landlord can proceed with the writ of possession and remove you while your appeal is still pending. This means low-income tenants have effectively lost the ability to appeal evictions unless they can come up with immediate cash. Number 7, security deposits must be returned within 30 days or you can sue for triple. Texas law gives landlords clear rules about security deposits, and tenants have strong protections if landlords break these rules. The landlord shall refund a security deposit to the tenant on or before the 30th day after the date the tenant surrenders the premises. But there's a catch: the landlord is not obligated to return a tenant's security deposit or give the tenant a written description of damages and charges until the tenant gives the landlord a written statement of the tenant's forwarding address. You must provide a forwarding address in writing. Email counts. A letter counts. Text message might count if your lease allows electronic communication, but you have to provide it. Once the landlord has your forwarding address and you've moved out, the 30-day clock starts. If the landlord withholds part or all of the deposit, they must give you an itemized list of deductions with a description of the damages. This list must be specific. Cleaning is not specific enough. Replaced carpet in bedroom due to large stains is specific. Section 92.109 allows the tenant to sue the landlord to recover 3 times the portion of the deposit wrongfully withheld, plus other fees. If your landlord keeps $500 of your deposit illegally, you can sue for $1,500 plus $100 penalty plus your attorney fees. The courts may presume bad faith if a landlord doesn't return the security deposit or supply an itemized list of deductions within 30 days after the tenant leaves the property. You can file this lawsuit in Justice Court, also called JP Court or Small Claims Court, if the amount is under $20,000. You don't need a lawyer for Justice Court, though having one helps. The filing fee is usually between $50 and $100 depending on the county. Landlords can only deduct from your security deposit for actual damages beyond normal wear and tear. They cannot charge you for things that were already broken when you moved in. They cannot charge you for normal aging of the property. Worn carpet from regular use is normal wear and tear. A large red wine stain on the carpet is damage. Number 8, late fees must be reasonable under Texas law. Texas law allows landlords to collect reasonable late fees if any portion of the rent remains unpaid more than 2 full days after it was due. But what counts as reasonable? The Texas legislature passed Senate Bill 1414 in 2019, which put specific parameters on the amount that a landlord can charge. Before this law, some landlords were charging $200 or $300 late fees on a $1,000 monthly rent. That's no longer allowed. The law sets clear limits. For the initial late fee, landlords can charge the greater of $25 or 2% of the monthly rent. For monthly rent of $1,000, that means a maximum initial late fee of $25, since 2% of $1,000 is $20, which is less than $25 for monthly rent. T of $2,000, the maximum initial late fee is $40, $2% of $2,000. If rent remains unpaid, landlords can charge an additional late fee for each subsequent 7-day period that rent remains unpaid, but these additional fees are capped at 10% of the original late fee. So if your initial late fee is $40, additional weekly fees can be up to $4 per week. However, the late fee provision must be in your written lease. In order to collect a late fee, the landlord must have included notice of it in a written lease. If your lease doesn't mention late fees, your landlord can't charge them. Also important, the average grace period for late payments in Texas is 1 day. If rent is due on the 1st, it must be paid by the 2nd, or the landlord can charge a late fee starting on the 3rd. Some leases give you a longer grace period, like 5 days, but that has to be written in your lease. If your lease is silent on grace periods, the default is 1 day. Number 9. Landlords cannot retaliate against you for exercising legal rights. Texas law prohibits landlords from retaliating against a tenant for exercising a right given to them by law or by the lease. This protection is found in Texas Property Code Subchapter D. What counts as retaliation? These rights might include requesting repairs, complaining to a governmental agency about building, housing code, or utility problems, or participating in a tenant organization. Landlords cannot raise rent to punish a tenant for exercising their legal rights. If someone reports maintenance issues to a city inspector, the landlord can't suddenly raise their rent. That's retaliation, and it's illegal. If you call the city health department because your apartment has mold, and your landlord responds by raising your rent $500 per month or trying to evict you, that's illegal retaliation. If you request repairs in writing and your landlord responds by filing eviction papers, that's illegal retaliation. The law gives you a 6-month protection period. If you exercise a legal right, your landlord cannot retaliate against you for 6 months from the date you exercised that right. Retaliation can include raising rent, decreasing services, terminating your lease, or filing eviction. If you believe your landlord retaliated against you, you can sue. You can use this as a defense in an eviction case. You can potentially recover 1 month's rent plus $500 plus attorney fees if you win a retaliation lawsuit. But you need to prove the retaliation, document everything, keep copies of all repair requests, keep records of when you called the city inspector, keep copies of emails, keep a timeline. If you can show that you exercised a legal right and your landlord immediately took adverse action against you, you have a strong retaliation case. Number 10. No rent control in Texas. Landlords can raise rent with proper notice. There is not a statewide law that places limits on how much a landlord can increase the rent when a lease is renewed. In fact, Texas law only allows cities to establish local rent control ordinances in certain cases. What does this mean? Your landlord can raise your rent by any amount when your lease expires and you're renewing for a new term. They can raise it $100 per month. They can raise it $500 per month. There's no cap. A state of disaster has to have been declared and the city must find that a housing emergency exists. The governor must approve the ordinance before it can go into effect. So cities can only do rent control during declared disasters with the governor's approval. This almost never happens. During your active lease term, your landlord cannot raise your rent unless your lease specifically allows it. Read your lease carefully. Some leases include escalation clauses that allow annual rent increases even during the lease term. If your lease doesn't include this language, your rent is locked for the duration of your lease. But once your lease expires, all bets are off. Your landlord can raise your rent by whatever amount they want. They just have to give you proper notice before the lease renews. What's proper notice? Your lease should specify this. Many leases require 30 or 60 days notice before the end of the lease term. If you have a 1-year lease ending on March 31st and your lease requires 60 days notice, your landlord must notify you of the new rent amount by January 30th. If you don't agree to the new rent amount, you don't have to renew. You can move out at the end of your lease term. But if you stay past the end of your lease without signing a new lease, you typically become a month-to-month tenant at the old rent amount until the landlord raises it with proper notice. Landlords cannot raise rent as retaliation or discrimination. If your landlord raises your rent by $1,000 per month 2 weeks after you complained about repairs, that might be retaliation. If your landlord raises your rent but doesn't raise it for other similar units, that might be discrimination. Texas R. Until laws just got serious and you can't afford to ignore them. If you're renting in Texas, save this video, share it with friends who rent, screenshot the key points. Check your lease agreement today, not next week, today, to see if you agreed to electronic notices. Set up email alerts. Know your rights before you need them. Drop a comment below telling me which part of this law worries you most. Are you concerned about the faster eviction timeline, the electronic notices, the appeal restrictions? Let me know. If this video helped you understand Texas rental law, hit that like button and subscribe. I post new legal explainer videos every week. Protect yourself, know your rights, stay informed. Thanks for watching.